The rules of professional conduct, both by the American Bar Association and in every state that I've ever reviewed the rules for, provide that in order to represent a client, one should have an engagement agreement. In the old days, an oral engagement agreement sufficed, but in today's world, the rules of professional conduct are encouraging, if not requiring in certain circumstances, that the engagement agreement be in writing. A good engagement agreement in today's world should include a number of things. One of them is the fee to be charged. Is this going to be an hourly fee, a contingent fee, or a value-added fee? And sometimes in today's world, the value-added concept is defined as a fixed fee or an hourly fee with a plus or minus based on certain characteristics or certain criteria, sometimes just totally at the client's discretion. Another value added is the discounted hourly fee with a bonus if successful. Oftentimes that bonus, again, at the discretion of the client, can be with certain criteria or just at the whim, if you will, or at least at the subjective criteria of the client. Another element of the agreement is how will this fee be calculated. For example, it's simple. If you're an hourly, it's just the number of hours times the rate per hour. If it's contingent, again, it's real simple. It's the percentage times whatever the recovery. If it's a defense orientation, the recovery may be based on how much money is paid by the defendant that is less than the reserve set up by the defendant. However you set this up, the method of calculation, the arithmetic, if you will, has to be set forth in the engagement agreement. Another element of the engagement agreement is when is the fee to be paid. Again, hourly, simple, every month. Contingent, you have to wait till the event occurs. One of the things that really bothers me about many attorneys in their thought process is that they understand that they have a written fee agreement. Client understands that there's a written fee agreement. Client doesn't honor the written fee agreement, and the attorney kind of lets it go. Well, now it's not 30 days, it's 60 days. It's not 60 days, it's 90 days. But what the lawyer forgets is that this is a two-way street. It's an agreement that's been signed by both parties, each to do different things. The lawyer to perform the services competently, the client to give whatever documentation is needed to the lawyer to help the client, to tell the truth, and to pay the bill. And so it seems to me that it's really inappropriate for the lawyer not to take care of himself or herself by forgetting what the contents of the engagement agreement are. As I've said on numerous occasions, it's better to take a loss with a small amount than a loss with a big amount. And the sooner you bring this to the attention of the client, the sooner the client will pay your bill, the better off you'll be. And that brings me to another element within the engagement agreement, and that is, what are the consequences of non-payment? Now, if the client does not pay the bill, the next step, in my opinion, that needs to be that needs to happen for the lawyer is that the lawyer has to begin or implement a collection policy. Now, what this means is that before you ever sign an engagement agreement, that you actually develop and have a written collection policy. That gets us to the end of the engagement. Now you have sort of the end of the matter, or in many cases where matters take more than a few months or even a few years to get settled or resolved in one way or another, is the end of the year, what I call end of the year haggling. Why wait till then? Well, one of the reasons is that their compensation is determined for the following year by how much they collect this year. The bonus at the end of the year is often determined by how much money they collect from the clients this year. But when you give a discount to the client, what you're saying in effect is, A, you don't value yourself. B, You don't value the services that you've performed. That is, if you charge $200 an hour, but now you're willing to give a 10% discount as an example, your real value actually is only $180, not the $200 that's on the piece of paper which represents the engagement agreement. And three, the client learns not to trust you, not to respect you. And as a consequence of that, they are likely not to give you future business. They're likely not to refer other clients, other colleagues and friends of theirs to you for future legal work. Discounting never does anybody any good. You've made the agreement in the beginning, and yes, I know you've got to get the money collected, but maybe you need a different client if you can't have a client that pays in full the amount they agreed to pay. That's a tough lesson, but in today's world, we live in a tough economy, and you need to protect yourself. Thanks for joining us today.